Cross-examination, that skill that most attorneys are afraid of it because they don't understand it and because they believe what has been said about it. Most attorneys believe that it's the most difficult skill to properly perform in the courtroom, and that is absolutely not the case. If you approach it properly and organize it in the right way, you can be extremely effective as a cross-examiner, regardless of your personality and regardless of your level of experience. There are really 7 things that I need to do to be an effective cross-examiner. I have to perform my case analysis. I've got to have a clearly defined purpose for every set of questions that I ask the witness. I have to understand control techniques, ways to get the witness who's being difficult, who won't respond, back under control. And those include something as simple as raising your hand and restating the question, or saying, "Ma'am, thank you, but that was not the question that I asked you. Did you understand my question? Let me ask it again." There are various control techniques that you must develop, but you've got to be certain that you use details in the structure of the cross, because details give you control. Details make the difference as to whether or not you're in charge or the witness is in charge. If you're going to impeach the witness with a specific means of impeachment under the rules of evidence, then it needs to be an impeachment that matters, so that when you're done, both you and the jury understand that something important has just occurred. And whenever possible, in the development of the cross-examination, use the witness's own words to force agreement. So those are the things that we think about as we begin to develop cross-examinations that work. We cross-examine for 3 reasons: to introduce a fact, to highlight a fact, either to strengthen it or weaken it, or to attack the credibility of a witness, or to strengthen the credibility of another witness. These are the reasons that we cross, and once we understand that, we can use these fundamental reasons to create effective cross-examinations. What are the basics? Lead. 1 fact per question. And each subset of your questions have a logical goal. We start in the back and move to the front. You want to be at that point where when you ask the last question, everyone in the room knows, based upon the answer to your earlier questions, what the response must be. And if they don't get that response, they have a moment of cognitive dissonance, of disbelief, and they don't believe the witness. And when that happens, you've won. So, leading questions. What is a leading question? You may have heard this, you may have even been taught this by your trial advocacy professor, assuming that you had one. You went to the store, correct? You got out of the car, didn't you? Isn't it true that you were there that afternoon? These are all examples of taglines where I add the words, isn't it true, isn't it correct, wouldn't you agree, isn't it so? There's a much cleaner way to do it. You got up that morning. You went to the store. You got out of your car. You walked to the front door. Now that's an example of cross-examination using statements as questions. It's a perfectly acceptable means of cross-examination and is actually in some jurisdictions now the preferred mean. So the nice thing about it is it gives you control and lets you establish the flow of the story of your section of the cross-examination. And it lets you do it in a way where you can drive the train, because you can cross with very few words, focus specifically on the fact that you want to get out. And cross-examination is all about 1 fact questioning, where the witness has no choice other than to give you the answer that they have to give. You'll notice I was also using voice inflection in both of those examples. So why do we use leading questions on cross-examination? Because there are some folks who say, hey, you should never use leading questions, or you should mix them up. Occasionally,